and good morning, everyone. Thank you so much for joining us here today at the OECD for the 2025 OECD Competition Open Day. Our first panel traditionally has been, and will be this year, a conversation with heads of competition authorities focusing on recent development in competition policy and competition enforcement. And this year, we decided to focus on the interaction that leaders of competition authorities have with their policymakers, politicians. How do you basically convey the message, the prophecy of competition to policymakers, especially when competition is facing growing competition from other policy areas? To have this conversation, we have three guests with us. So to my right, Doris Tshepe, who is the Commissioner of the South Africa Competition Commission. To my left, Matthew Boswell, Commissioner of the Canadian Competition Bureau. And online, joining us, Andreas Mundt, President of the Bundeskartellamt and Chair of the ICN Steering Group. Thank you, all of you, for joining us here today. So originally, we should have delved right into the main question of discussion, but I'm taking myself the liberty to hijack the agenda and go off script. And maybe, we've seen some major changes in the international landscape in the last several weeks, months or so. And I would like just to give you the opportunity to give us your take. Competition has not been in the focus of discussion so far, at least. But just your quick take of where these changes may lead in terms of the future of competition policy. So Matthew, maybe you'd like to go first.
Yes, thanks, Ori, and good morning, everyone. A little bit of turbulence in the last month or two, and likely a lot more to come. I think that's a pretty safe bet. I think in terms of competition, and there are some things out there that are being said about competition that are troubling to me, but in terms of how competition agencies, competition policy handles some of the turbulence, I think we have to stay the course as we did during COVID, stick to the fundamentals, and be very vocal about the fundamentals and the importance of competition for the consumers in our jurisdictions, for businesses in our jurisdictions, and to sort of fight back against temptation to respond to turbulence by giving carve-outs to competition law or putting competition law on the back burner temporarily to deal with the issues. We didn't do that, at least in Canada, during COVID, where there was tremendous economic shock and there were calls for that. So I think that's going to be very important, is for competition agencies to be vocal and to remind their governments and their citizens about how valuable sticking to the fundamental principles of competition is in times of turbulence. I can say, though, that I am concerned about some other sort of recent dialogue around competition, about the notion that merger review somehow inhibits growth. I think that's something we have to be very concerned about and sort of fight back against what I think that is a false narrative. I'm also concerned about what we're seeing in some jurisdictions about changes to agency structure, agency reporting lines, what some might call diminishment of independence of competition law agencies, and concerned about what that might do in several ways, including what it might do to international cooperation. So there's a lot to be worried about. There's no doubt about that, but we got to stay the course.
Thank you very much, Matthew. So Doris, Matthew painted a very interesting analogy between the current times to COVID. Maybe you have a more optimistic take?
Thank you, Ori, and good morning to everyone. Thank you for having me here. I think I wanted to touch on something that Matthew spoke about, and that is rallying around support for multilateralism. I think during this very difficult, turbulent time, I think for us, I think we need to make sure that this shift more towards a mercantilistic thinking, prioritizing what our national economic interest, see it as a risk of threatening to undermine the multilateral institution and cooperative global governance. I think we've seen, I think, from a developing country point of view, that multilateralism should be the building block for mutual and shared creation of wealth, and lifting billions out of poverty, and for resolving geopolitical disputes. At this point in history, I think it's very critical that countries need to stand firm in support of this, and from a South African point of view, we've seen this, and as the presidency of the G20, we think it's quite critical that multilateralism remains a key focus for us. Obviously, competition policy will not be immune from all these turbulence, and we need to be looking at global cooperation as needed more than ever to deal with global market issues. And we've heard earlier on AI, digital markets. These are global issues that are affecting markets across the globe, and no one jurisdiction is going to be able to tackle them. And so cooperation amongst institutions will remain important. And I think for me, it is important as competition authorities that we recommit to cooperative institutions like the ICN and a network of mutual assistance to ensure the spirit of multilateralism remains strong. We should also collectively deal with these threatened retaliation as competition authorities. We try to fulfill our mandates to protect our citizens and businesses from market power abuses. And I think for me, if we are to recommit to these, we should be able to deal with some of the tensions. And I think we do at the same time as competition authorities need to be responsive, and we'll touch on that when we discuss the issues on competition policy and other policies like industrial policies. How are we responding to industrial policy which is a pro-competitive industrial policy across the globe to ensure that we are more responsive? I think that's where I'll leave it. Thank you.
Thank you, Doris. Andreas, over to you.
Thank you so much, Ori. Hello, Ori. Hello, Doris, Matthew. You can imagine how sad I am that I cannot be with you in Paris today, but my health is in a state that I'm happy that I made it to my office this morning, and there was no thinking of traveling to Paris today. So, but I'm all the more happy to be able to contribute. And of course, I agree with what Doris and Matthew have said, but I would like maybe to add some aspects. There are lots of crises going on around the globe. Here in Europe, we still struggle with the Russian aggression in the Ukraine. We see how large blocks are building around the world. We know about China, we know about the US. I hope, and here I take a very European perspective, that Europe is waking up for the time being, that Europe is going to search its own way forward. We will have a new German government, and everyone expects strong leadership from this government, not only for Germany, but also for Europe, and give an important weight to Europe's interests. So besides all these developments, what we also see are technical developments. If you think of AI, that is changing the industry landscape as well to a certain extent, speeding up technologies, also speeding up maybe problems that we have in big tech markets anyway. So we have to find our way in this. And where is competition policy headed now? I think what is different this time that it is not only disruptive from one side as it was during the COVID crisis, that was COVID, but now there's disruption from a couple of sides. There's a change of values, there are new forming blocks, there is technology, there is new governments coming into place that play a very disruptive role themselves. That is the disruptive side. The firm and stable side is it remains as it is. Nothing can do for wealth and innovation what competition can do. And this is why it is so important that we as competition agencies, that we stand firm, that we speak up, that we continue to advocate for competition worldwide, individually as agencies, but also in international organizations like the OECD, like in the ICN, and send this strong message to governments how important competition is. And by the way, no functioning competition without functioning competition agencies. And here I echo what Matthew has said. That also worries me in some areas of the world. That competition agencies get into some turbulences to a certain amount. We will see disruptive changes, I'm afraid, to a certain extent. Even if I look at the OECD, will it remain as it is? If I look at all the topics that we tackle there with regard to gender equality, sustainability issues, will it remain the same if I look at the new administration in the US? I'm a bit skeptical. So I think what we can say today, we see all these turbulences. I would say neither the OECD nor the ICN are yet affected yet by these turbulences, but that might change. So I would say from this point of view, we are not yet in very turbulent times as competition agencies, at least most of us, and certainly not here in Europe, but that might change. So I think the situation is not so turbulent for us yet, but it is pretty unclear, and it is very difficult to predict, even for the upcoming weeks and months, what is to come. And this is why I think we have all good reasons to be loud, vocal about competition and competition policy and competition agencies, that we do not get affected too much by what is upcoming.
Thank you, Andreas. Moving now back to the core of the agenda of this session, from the international arena to the national one. And as we were saying, competition is facing increasing competition from other policy areas. Just to name some of them, Doris, you mentioned industrial policy, we have innovation and growth, and policymakers often question whether these other policy priorities are 100% in line with competition. So, for example, you mentioned, Andreas, in Europe, the Draghi report raised some question marks over the way merger control is being done. In Canada, on the other hand, a recent amendment to the Canadian competition law shifted the balance in favor of competition compared to efficiencies that it used to do in the past. But Doris, if I may, I would like to give you the floor first, since as the head of the South African Competition Authority, you already, I mean, as part of your day-to-day work, have to balance competition against other social interests. And how do you make the case for this, for competition in this very complicated environment? If you also can provide one or two examples for that.
Thank you, Ori. Perhaps let me start with the the criticism Matthew raised earlier about the pressure that competition authorities are faced with on competition law to deliver growth, and we've heard this happening or being said quite a number of times, and we've seen that in the UK. There are murmurings in the South African press, particularly business press, even within a context where South Africa, legislatively, we have both competition and public interest provision. So I do want to engage a little bit on those, because I see some of it as a bit of a risk, and I think as we need to find a way of managing this risk of a narrative of, particularly in merger control, that merger control is not pro-investment. And we, as competition authorities, I think we need to find a way of making sure that we make this narrative go away and show the positive aspect of merger control. And I think to manage this risk, I think agencies do have to respond to current growth and industrialization imperatives while positioning competition law within that agenda. I think making sure that it is at the heart of competition law is at the heart of that agenda. First, I think part of the investment and growth debate in South Africa, at least, is focused on excessive regulation that slows investment decisions and hinders a dynamic economy. And in our view, I think regulation is essential to reduce risks, like anti-competitive markets. But sometimes excessive regulation occurs when small risks are regulated. So competition law is no different and needs to respond to regulation reduction agenda in some instances. And in our view, this should not be through abandoning enforcement for big risk, but rather withdrawing from smaller risk. For example, in South Africa currently, we're looking to raise merger threshold by significantly reducing percentage of merger filings that should be notified to the Commission. And we think by doing that, you will reduce some kind of smaller risk. And I'm calling them smaller risks because if you look at our research, you'll find that a large number of measures that we are approving, it's without conditions because they don't raise both competition and public interest concerns. So we think we could be responding to some of these concerns by looking at some of the work that we're doing. And that is with regard to measures. We've recently, I think on Monday, launched a provisional report in the Media, Digital and Platform Market Inquiry. And what we've done is deliberately not taken an inflexible regulatory approach to remedying some of the provisional findings we're seeing in media and digital platforms in relation to some of the harmful conduct we've seen. Only one piece of regulation has been recommended, and that is to deal with misinformation in the media. But the rest is to try and look at independent actions by platforms to resolve harmful conduct, focusing primarily on the outcomes we wish to see and leaving open to platforms to find the most practical ways to achieve these outcomes. These outcomes could be achieved in other ways in future should the platform or markets change, for example. So what we've seen is the mechanisms that we've seen in Canada or in Australia on media and digital platforms may not always be responsive. I mean, in Canada, you saw Meta closing down news, for example, and we think trying to resolve them and finding some win-win situation, a resolution to that might be quite helpful for us. Secondly, you've mentioned the OECD report on pro-competitive industrial policy and the Draghi report as well. This is an opportunity to, in our view, to put competition at the center of industrial policy and innovation. The South African government, like most government, are looking to industrialization as a strategy to kick up growth in the economy. However, to do so, competition law, in our view, needs to be responsive to the targeted sectors and be focused on rapidly removing barriers and pro-competitive reforms. We're looking, for example, at fast-tracking conduct changes to open markets in past through fast-track investigation for industrial policy targeted sectors, and looking at settlements in enforcement cases where firms are looking to change behavior more quickly. This will also be done in collaboration with government agents, other agencies or departments, to unblock issues rapidly and to ensure that all levers are working towards the same goal while putting competition at the center of any other policy, whether it's trade or industrial policy, for example. So we're working closely with other governments, departments to solve these problems. For example, we have been working with other agencies and other government departments to using exemptions to address issues in health. In energy, you would recall we've heard what we call load shedding in South Africa, which had required some exemption to allow parties within the energy sector to come together to deal with some of the constraints that are faced there. We have been working in collaboration with the Department of Health to try and look at price for essential drugs, particularly in TB in South Africa. So for us, I think these are some of the ways in which we could look to work together towards achieving competitive markets. But lastly, I think in relation to measure control and enforcement, the South African public interest provision allows us to look at national imperatives to balance against competition imperatives, and we've done so. And for us, we think, and this is firstly in law, so that everyone who participates is aware of what the parameters are. But it also requires a more evidence-based approach to the balancing, rather than leaving this to political lobbying process where investment is promised that in some instances might not even be happening anyway. So for us, we have found a mechanism of finding legislative framework, but also an evidence-based approach to assessing this. Thank you.
Thank you very much, Doris. Andreas, how do you make the case for competition in Germany against competing public interests?
Yeah, many thanks, Ori. In Europe, we have, I take the European perspective, of course. In Europe, we have an ongoing debate about industrial policy, yes. But in fact, it's not so much about industrial policy, that is the headline. I would say it's more about how do we regain competitiveness in Europe. And also, if you look at the Draghi report, the question of competitiveness is the key question that is followed by this report. There are more papers like that, the letter report, also the competitive compass of the EU Commission that has been presented about a month ago. And indeed, we are lacking competitiveness in Europe. We lose jobs, we lose industries, we lose value creation. Wealth is moving to other continents, other countries in a certain extent. And the key question indeed is how do we regain this competitiveness in order to keep innovation industries, companies here in Europe? That is what, at the core, what the debate is about. At the core of this debate, again, indeed, there is the Draghi report. And if you look at the Draghi report, that is most interesting, you find literally nothing, almost nothing on weakening competition rules. And for very good reasons. Just to give you one example, if you look at DG Comp, that has looked at 10,000 mergers since 1999. DG Comp has prohibited 39 mergers. And I think it would be quite exaggerated if you would deduce from these 39 mergers that have been blocked that has been chilling innovation or the competitiveness of Europe. If you would take that conclusion, that would be ridiculous in a way. It would be a bad joke. So the question, in my perception, is not what needs to change in competition law in order to regain competitiveness. The question is, did other areas of policy in Europe work as well, have been as agile, have been as adapted to the economic and technical development as competition law has been? So it's more about unleashing the offer, releasing the economy in other areas that are of great importance. So, just to give you an example, if regulation, if bureaucracy, if subsidies were a successful model, Europe would be the most competitive area in the world. One example is the AI Act. We just know about the recent headline from the US. OpenAI, SoftBank, and Oracle are launching the Stargate project, altogether $500 billion of investment. Europe at least has to offer 1 billion to offer, but the headline in Germany at the same time was more than 100 new jobs for the Federal Net Agency to enforce the AI Act. I do not really know if you ensure competitiveness by looking at regulation only. So deregulation in Europe is what needs to be done. Reduce bureaucracy significantly, and not just with some fine and sophisticated brush strokes. Reduce the state to a framework builder, again, not so much as a player in the economy and in the industries. We need lower energy prices, we need better education, we need skilled workers, we need tax reforms, especially in the area of corporate tax. We need a much higher investment in infrastructure, be it physical or digital. And all this together will foster competitiveness. And here, Draghi again, we need a capital markets union. We need a telecom markets union. By the way, this is the only way where I've made some problems with the Draghi report, where it says we need to be a bit more reluctant on telecom mergers at the national level. No, we need not to be more reluctant at the national level. We need to decrease regulation in the telecom sector in order to foster cross-border mergers between telecom companies. So what you hear about competition law in this sense, to be frank, you do not hear very much. Also, Draghi does not say very much on this. He speaks about other areas. By the way, this does not mean that the state should not improve conditions for certain strategic and specific industries. I think especially digital markets are such an industry in the EU for which industrial policy in a certain way could be very helpful to improve the digital infrastructure, to make sure that we create a European cloud system, also to foster and guarantee European sovereignty. I think all these are thoughts of a very effective industrial policy that do not get in the way of competition policy. And it must be very clear that competition and competition policy are, of course, an integral part of all this, but it must also be clear that in the past, we haven't done bad homeworks in Europe with regard to competition policy, also reflected by the report of the European Union on protecting competition in a changing world. There are some areas where I think we need to do some more killer acquisitions in Europe. How to catch them, how to intervene is to a certain extent an open field. Acqui-hire cases, maybe slimlining abuse control in order to be more effective. I think these are areas where we could do more with regard to competition law. But in general, I do believe that we have a very, very well calibrated system of competition law, of taking into account what needs to be taken into account. We have agile competition agencies who are used to follow the economy, who are used to be part of that economic game. So I'm not so much worried about that. I do hope that we have the power and the advocacy power to bring that to the minds of competition of policymakers, so they turn to the right fields in economics and not so much think about what needs to be done and changed in competition law. But again, if you look at the Draghi report, all that I've said is reflected in there. And even if you find if you look for a sentence on weakening merger control, you only find it with regard to telecom mergers. I said that already, in national markets. But if you leave that aside, the rest is very well concerned about other areas of law, not about weakening competition law, although many people deduce that from the Draghi report. I do not really see why.
Thank you, Andreas. Matthew, over to you.
Yeah, so going back to your question, you talked about some reforms to Canada's merger law. What in fact has happened in Canada over the last 3 years is dramatic, sweeping reforms to all our competition laws. And that's part of what I and others like to refer to as the Great Awakening in Canada about the importance of competition. And so right now in Canada, and I don't see this changing in the near future, competition is not being pushed aside by any other public policy discussion. In fact, it's this sort of great awakening and emphasis on competition in Canada is driving other discussions about how to improve competition after all these tremendous reforms to our law. I mean, I would, say to folks, if you want to point your government to how weak competition law can hinder productivity growth, can hinder innovation, can harm consumers, you need only look at the situation in Canada for several decades, where we had arguably the weakest merger law, certainly among OECD peers. We had terribly onerous abuse of dominance provisions. We had weak fines and penalties. I could go on and on. And over the course of the last 4 or 5 years, there's been a significant advocacy push by the Bureau and others to make Canadians aware of how bad the situation was in terms of our law. And what's happened is parliamentarians, politicians in Canada, as a result of public awareness and public clamoring for change, have fully gotten on board with the fact that competition policy, competition law can no longer be the elephant in the room in Canada, and that it's something we need to urgently address for productivity growth, for greater innovation in the country. So this notion, as I said in my first answer, that we need to allow more mergers for more growth, that this has been kicking around lately, that is not something that's on the radar at all in Canada. That said, so that's dealing with private restraints on competition, and I'll talk about this a bit later, but we, like Andreas mentioned, have tons of work to do on public restraints on competition in Canada through regulatory barriers to competition. And this leads me to the sort of maybe the last thing I'll say about the intersection of what's going on and public policy goals and competition. So obviously, there's a threat against Canada of tariffs. That's very well known. And what it has done in Canada, which I find fascinating, has drawn great attention to the fact that we have significant internal trade tariffs, internal trade barriers and tariffs between our provinces. And the Bureau's been calling this out, the Competition Bureau's been calling this out for years as something that hinders competition within the country, holds our productivity growth back, holds our GDP growth back. And literally in the last month and a half, there's been a very significant push on taking down those internal trade barriers within Canada to allow our economy to flourish in the face of potential external tariffs. So the overwhelming dialogue in Canada is about how do we get more competition in our economy. And the senior deputy governor of the Bank of Canada last year gave a speech that got tremendous coverage in Canada that talked about how we were at a break the glass moment. It's, there's a productivity crisis in Canada. And she said that, the key or one of the main keys to solving this problem in our country was through competition to drive productivity growth. So we're not in a situation where other public policy areas are pushing down competition. Competition is very much at the forefront of Canadian politicians' minds and really of Canadian consumers, Canadian citizens' mind going forward. So that, for me, that's a positive. Unfortunately, it came after several decades of weak competition law, but we have to go forward and make the best of it.
Thank you very much, Matthew. Let us move forward now to the interaction that you have with your legislators. So as we mentioned, 2 out of 3 of the agencies around the table have recently major reforms to their competition law. You mentioned, Matthew, the reform that you had, especially on mergers, and I think in Germany there was a reform focused on market investigations. And the question that I would like to raise here is, if you can, to the extent possible, open the door to us and let us into the room where you have conversation with your legislators. How do you manage to get the amendments to your laws that you are keen on? And I should maybe say, not get the ones that you are not so keen on. What's the secret to getting the right competition law? And Andreas, I'll let you go first, if you don't mind.
That is an excellent question, Ori. How do you get what you need? And how do you make sure that you don't get what you don't want? That is very difficult, I must say. One thing is for sure, in Germany we have seen several amendments of the German Competition Act. I think it's hard to find a legislator worldwide who is more agile also on following new development, and sometimes we are very grateful for that. That our toolbox is up to the tasks that we need to take up as a competition agency. Indeed, there have been reforms on digital markets. As a result, there was the new Section 19A, the special provision in our competition law on tech markets. We have received the so-called new competition tool just recently, which is closely interlinked with sector inquiries and so on. So in general, I would say we are deeply involved in all processes of legislation. We accompany the legislator. There are hearings in Parliament where the Bundeskartellamt is heard. I'm in contact with members of Parliament on these legislative projects. We also have an excellent contact with the relevant ministries, for example, when it comes to the new competition tool with the Ministry of Economics and Climate Protection, but also with the Ministry of Finance. So I think that is essential in a way, that you have a good contact, also a good personal contact with those who in the very end take the legislative decisions, because we can only give advice and hope that our advice is followed. But of course, it is as always in life. Normally, you don't get exactly what you need. It's always a compromise, especially here in Germany, where government normally is carried by a coalition. So there have been compromises between those parties, fractions in the Deutsche Bundestag that carry that coalition. And that can be very seen by the recently introduced new competition tool that we have received in Germany as a new instrument in our toolbox. It's a tool to intervene below the threshold of an infringement of competition law if competition is not working very well in a certain industry or a certain branch, and then we can take literally all adequate measures in order to foster competition. That new instrument was highly disputed in Germany. You can see that from the fact that the CDU, which has just won the election on Sunday here, has very few about competition law in its party program. What one sentence is that they are going to abolish the new competition tool. So we will see if this is going to happen now. The Greens also had this instrument in their party program. They want to introduce it at the level of the EU as well. What happened in Germany is when the new competition tool was introduced, there was one party who wanted it, and we got it, and there was another party who did not want it, and that led to the effect that it is a tool now with many hurdles and barriers to be applied in practice. It has become very bureaucratic. It will be a complex tool to apply. So that happens, of course, because, as I said, as competition agency, you are not the legislator. You're just given advice, but in the very end, it's a political decision how such an instrument is shaped. The important thing is that policymakers are open for your advice, that you have the relationship with policymakers, be it at the ministerial level, be it in parliament, so you can try to get a foot into the legislative process and to give your advice. Another positive example for that, in my perception, was the amendment on big tech markets, on digital markets, Section 19A. In my perception, that is a very successful tool. It is in place now already for a couple of years. It's not easy to apply as well, but we can handle it. We have designated all major big tech firms by now. Google, Apple, Facebook, Amazon, and Microsoft are designated. We have some confirmations by the court on this designation too, by the Federal Supreme Court in Karlsruhe. So that was quite successful as well, and we are applying this tool very successfully. You can see that from the fact that we have a couple of far-reaching behavior cases ongoing. Some of them have been closed. Some of them are shortly before being ended. Just to give an example, was the recent statement of objective on the app transparency tracking initiative vis-a-vis Apple, in which, by the way, we have cooperated with other national competition agencies in Europe. So these are all tools where we have been deeply involved and in which we could at least give as much advice as possible. Sometimes as a competition agency, you also have to deal with a complete failure. That was in the area of merger review with hospitals. that was more or less to a big extent excluded from competition law just recently, because there are huge reforms with regard to the structure of the hospital markets in Germany going on. Competition law has been put aside. We lobbied strongly against that, but we were not successful. So we will see now in the future how a market is working, where competition law or merger review law de facto does not play a role, and how well this market really functions in the very end if it is just subject to regulation stemming from the public health sector. So you see, I think we are well connected with those who are in charge of competition law. Sometimes we are successful, but there are also failures, and I'm sure every competition agency around the world might be able to tell similar stories.
Thank you, Andreas. Matthew?
Yeah, so in Canada, we have our structure is such that the Competition Bureau is independent of the government, but we have a sort of relationship with the ministry. So we're an arm's length organization like many, but we do not have the policy function. And lots of people in Canada think that's correct. We shouldn't have the policy function. So what, 5 years ago, we began advocating for the changes that I've talked about already today. And in order to do that, it was not really on the table to go and talk directly to politicians. People saw that kind of interaction as a bit too direct for an arm's length law enforcement agency. So what we did, at least at the outset, was begin to make the case to the public that I've talked about earlier, make the case to citizens on how valuable competition can be for them in their lives, how it can lower prices, give them more choice, and build that up through our own advocacy function, which is part of our remit in Canada. And then in early COVID, we had the affordability crisis. People started looking to the Competition Bureau more. There were controversial merger cases, other controversial enforcement cases that highlighted flaws in our laws or gaps in our laws. And all of that sort of led to much more interest by legislators in Canada at the federal level about how they could help us, how competition could be strengthened. And so we adopted a very clear strategy, which was going in front of them. They would call us to parliamentary committees, and we would be incredibly direct about the failings of the law, the gaps in the law, very honest with these parliamentarians. And we did that through evidence. We showed what other countries had in terms of how their laws were structured, how we were out of step, how our legislation had been, when it was first drafted, the ideas were unique, but showed our government that they didn't work. And this sort of relentless demonstration of the failings and how to fix it, we provided actual examples. For example, recently embedded in our law now is the rebuttable structural presumption that is included in the US merger guidelines. We put that forward and demonstrated how exactly it worked, how it was still fair that parties could rebut it. Anyway, we engaged in this process over several years and succeeded in getting probably 60 to 70% of the reforms to our law that we set out to get at the beginning. So it was kind of a long strategy. In terms of avoiding amendments or additions or tasks that you don't want as a competition enforcer, I think it's the same thing. We have been very honest and direct at parliamentary committees when there's a politically convenient idea out there, like, oh, we can just tell the Competition Bureau to do that or this. You know, a great example is when during COVID or the period just after COVID, when affordability was a huge problem in Canada. It continues to be, but it was much worse a few years ago. You know, there would be politicians often floating, well, you know, can we just regulate the prices? Can the Competition Bureau oversee that? And we would, you know, be like very repetitive. We are not a price regulator. We don't want to be a price regulator. Do not make us a price regulator. It's a bad idea. It's not pro-competitive. It's not good. Or when politicians would say, well, you know, that must be collusion. Their prices are the same. Go charge them with a criminal offense. I have to say, no, we need evidence. There's something such as conscious parallelism. You just have to be very direct with them and tell them that's a bad idea. And sometimes it's unpleasant in the room and in the committee when you do that, but it's certainly better than getting a nightmare provision added into your law that you don't want.
Thank you. Doris.
Thank you, Ori. I think we've all been there as competition authorities. What we've done in our law, we have a provision allowing us to provide advice to the minister on competition where there may be either under enforcement or some concerns on us achieving our mandate. So the Act requires us to do so. And with the not so recent, the 2019 amendments, that's what we did. We literally had to lead in diagnosing the problem with us achieving our mandate and advise the minister on those concerns, and some related to the functioning of market inquiries, standard of proof in abuse cases, which were more related to small and medium enterprises and historically disadvantaged persons and how they operate in the economy, and including measure reviews. So we were able to then provide a diagnostic report in a way to the minister and advise on some of this. And this has meant that we are able to then engage with the department responsible, Department of Trade, Industry and Competition, including proposals on those amendments, and like as both Matthew and Andreas said, we participate in the parliamentary review processes by attending and advising the minister and quite frankly being vocal, using our advocacy role in this. And we've seen some improvements in this. Obviously, you do get those provisions in the Act that come. Some to this day have still not been implemented because they are not practical to do so. But you can't, it is a legislative process, and we are an independent regulator, and when the legislature wants to put those, they do come on board. But I think for us, it's research and diagnosis of problems and how they can be resolved, so you become a source of solutions to problems that are there in the economy. I think that's how we have been dealing with it, and we've seen good results out of that. Thanks.
Thank you. We'll do one more questions, and then we will take some Q&A. For the last question, I would like to play a little game, a game of imagination. So bear with me. You're entering into a big building, and you're calling the elevator arrives, and you're entering. You need to go to the 50th floor, so you have some time. Let's say that it's a very tall building, but an old-style elevator. And just before the door closes, someone put their foot at the door, and the door is open, and then you realize that for you, Matthew, is the Canadian Prime Minister. For you, Andreas, it's the German Chancellor. And for you, Doris, it's the President of South Africa. And they enter the elevator, and they, of course, recognizes you immediately, and they tell you that they think you are doing great. They are supporting competition very strongly, and they would like to give you the opportunity to ask for one legislative amendment, whatever you want, carte blanche. They have a strong majority in parliament. They can make it happen. Which one would you like to have? And Andreas, how about going first? I know that German chancellor at the moment is in a transition period, but yeah.
Yeah, maybe I could meet the incoming chancellor, and
Okay.
he would recognize me. That's the good story. I have one idea. If I have just one wish, so to say, it would, to be honest, not be in the realm of competition law. It would be consumer protection. Some of you might know that we have the competence to do sector inquiries with regard to consumer protection, but we do not have the right to intervene if we find any deficits. We have done a couple of such sector inquiries, very good ones, sector inquiries from which we have gained a lot of expertise in this field. And what I would love is to have a competence to intervene, not in every single consumer protection case, but in cases of a general matter, and in cases where we see that lots of consumers are hurt, maybe just by one click and at the same time. I think that would be what I would try to bring in during this elevator climbing up to the 50th floor. I would start by saying, you know how well we apply competition law. Maybe you see a chance also to give some competences to us to do consumer protection law, and we'll do it in a proper way.
Okay, thank you. Doris, what's on top of your wish list?
We don't have a one government with majority in South Africa, as you know. It's a government of national unity comprising of 10 political parties. So that's, yeah, it will be a very interesting process. As I said, we had quite significant amendments in 2019. So for us, most of the amendments we would have wanted would have been there. There is talk, Andreas, in South Africa of merging consumer protection and competition. We are still investigating that. I'm not sure I will ask for it, because as it stands is both the individual consumer protection cases and the bigger issues. So I'm not sure we're ready for something like that. But what I would say, and this is in relation to just being a rapid responsive entity, competition authority, is I do think that we need to look at some procedural and appeal processes through the court system. Our enforcement cases are taking way too long, and I'm sure that's the case in many authorities, but on average, we take something like 10 years to resolve an abuse case. And I think we need to be looking at some reforms on procedure an appeal process in abuse. So that's the one issue I think I would think of and ask for, just so to ensure that we are more responsive as an authority. Thank you.
Thank you, Doris. So Matthew, you mentioned earlier that you got 60 to 70% for what you wanted. So maybe share with us the extra 30 that you didn't.
Well, we got all the good ones. So I'm going to cheat in my answer and talk about something, maybe a prime minister-led complete mind shift and a lot of work in Canada in terms of addressing public restraints on competition. So, as I said earlier, we've done a really good job of addressing the Competition Act with major reform, but we're a country that is declining, or I guess declining rapidly in terms of regulatory barriers to competition. And this is visible, it's not just me saying this is visible in the OECD PMR indicators. In 2018, if I have it right, I think we were second last in terms of regulatory barriers to competition in Canada out of the OECD countries that were examined in the 2018 version. In the most recent PMR, we had very low rankings on multiple different indicators of barriers to competition. And this is something that the Competition Bureau has been advocating for multiple years. We produced a competition assessment toolkit based on the OECD one years ago and urged our regulators at all levels to adopt that. Unfortunately, it hasn't had the amount of pickup we'd like. So what I would say to the Prime Minister is we need a whole of government approach to competition in the Canadian economy, and that means federal, provincial, municipal, all governments, everybody pulling in the same direction to reduce these regulatory barriers. And I would also say, because we have 50 floors to chat, you're not inventing something. This has been done. This was done in Australia in the 1990s with their Productivity Commission and emphasis on unlocking competition in their economy that had huge benefits in Australia. I mean, very conservative estimates. In the 90s, it was 5,000 Australian dollars per household was the benefit of the work they did. They looked at 1,800 laws and regulations. And that's the kind of initiative that has to be led, I believe, by the Prime Minister, by the federal government, using the levers that it has in terms of transfer payments to the provinces and that sort of thing, which is what was done in Australia, to drive this significant reform to unleash the capabilities of the Canadian economy where there aren't all these barriers for small and medium-sized enterprises to contest in markets and to get up and running and to build factories and that sort of thing. So, yeah, that's what I would ask for. It's not an amendment, it's a mind shift.
That's fair enough. Well, we luckily have a few minutes to take a few questions. So please raise your hand. I don't know who carried the mic. Oh, Sophia, we have here. If you can just raise your hand again so Sophia can see you. Thank you.
Thank you for the opportunity. It's a quick question. So listening to the four people in the panel, it seems that there is a common understanding, at least in my interpretation, that it is good to make competition law resilient to geopolitical instability, and one way to do that would be to have a self-aware antitrust community. And here I'm not only mentioning antitrust community as enforcers, but also private sector and competition lawyers as well. I mean, Matthew mentioned showing what other jurisdictions do as an argument in Parliament. Doris mentioned multilateralism, and President Andreas mentioned about the ICN. So my question is, what is the main difference for you guys between the OECD, UNCTAD, and ICN? We all know the similarities, we all know the good purposes that they serve, and we all know that we are exchanging multilateralism already exists in competition law. But what is the main difference between them? Because this, I think, is something that is not usually explored, and maybe if we know the differences between each forum, we can then put a step further into how to exchange better. Thank you.
Thank you very much. Luckily, we have with us also the chair of the ICN steering committee. So I don't know if Andreas, you'd like to take this one first, or any of you?
Yeah, sure. Thank you, Ori. I think all of these fora, in a way, are complementary. If I speak for the ICN, I can say, of course, the ICN has a very hands-on approach. The ICN is an organization in which really case handlers learn how to deal with certain cases. Have there been other cases before? How do I do that? You can learn how to set up your agency as the head of an agency. You can learn how to deal with certain situations. So I think that is key of the ICN, is this very hands-on approach. That is one side. And the other one is maybe more similar to the OECD. We try to develop standards for proceedings. The best example is the area of mergers, where it was always at the heart of the ICN to make sure that companies, the competition, that companies and the lawyers do not face completely heterogeneous merger review practices around the world, but that we come to a certain standardization, not only of the laws, but also of handling how to do things. I think these are the key features of the ICN, whereas the OECD maybe takes a more conceptual approach. In general, for me, this is the key difference. And if I look at UNCTAD, I go there from time to time as well, but I'm sure that Doris will also say a few words still on UNCTAD. That is more for the political exchange worldwide. It can easily be seen from the fact that in UNCTAD you find the most members, even more than in the ICN. We have in the ICN around about 140 members. I think UNCTAD is close to 200. OECD is even less, so that is also a huge difference in my perception. But in general, what you can also say, all these organizations, in a way, are complementary to each other because all of us are, to a certain extent, engaged in all of these different international organizations.
Thanks for the question, and I think, Andreas, you are correct. I think with regards to UNCTAD, it has all members of the UN would be members of UNCTAD, so you have a much broader a compilation of authorities, in fact, participating at UNCTAD. And I think it's more also discussing policy direction and supporting also of developing countries in particular as well. So I think there is a lot of conversations that take place at UNCTAD on the policy direction of competition law than you would find more broadly, whereas with both ICN, which comprises mainly of competition authorities themselves, not government departments in a way, where we are exchanging views about our approaches and collaboration on cases, both at a senior level and even at a case handler level. So I agree that all of these are complementary and are necessary organization for all of us to be able to engage on issues that affect us as competition authorities. Thank you.
Thank you. Maybe we can take one more question. There is one here.
I am K.K. Sharma. I am the first Director General of Competition Commission of India and Head of Budget Control, and had some close experiences of the kind of discussion which took place just now on whether dealing with the competition law, bringing it into force and all. So I liked what Andreas Mundt and others said, but this is very easier said than done. I've seen politicians who come to the power, they have this belief at times, two things. First, we have come by political vote. Gentlemen, you are a just appointed entity. And secondly, it depends how headstrong they are. I've seen flip-flops in our case, how we got to enforcement and all. Leave that aside. I know of two countries, Oman and Afghanistan. Oman, they had an agency in place. I do not know whether somebody is around here. It was very much in place, and they reached out to have good framework in place. And lo and behold, there was some change in the government, and everything was kept in cold storage. No discussions, nothing. It happens in Afghanistan. Prior to this Taliban, let's not talk about Taliban, before that. And the biggest transport czar was the minister in charge of competition law. And the law was in a drafting stage, and it was kept aside. So this is very easy to say, but I want to know, when on the cutting edge you actually deal with politicians, is it really easy or it's very difficult?
I can assume it's difficult, but I let our experts reply.
Well, maybe it's probably a bit unique, the situation that we had in Canada, but it was a groundswell of citizens demanding more competition in our economy through a variety of reasons. But so when I went in front of Parliament as the Commissioner of Competition, what I found was different political parties in Canada competing as to who could amend the Competition Act the most. So there was a huge demand. There were 3 different bills passed over 3 years. 2 of those bills passed unanimously in our Parliament. The competition changes. Every single person on all parties voted for it. So, and the 3rd bill was a significant majority. So maybe for me, it's been a bit easier because there's such a groundswell of support for competition, enhanced competition laws in Canada, enhancing the powers of the agency. But I can see your point in other times where, depending on who the particular party in power is, you know, they might want to shelve things because it's not in their interest to have a vigorous enforcement agency, which is why it's important for us to be independent.
Andreas, Doris, would you like to go?
Yeah, I would just, on a quick note, I would say it depends. We have had ministers who have been extremely competition-minded, who have done competition policy in a way all their life as an active politician, and then became a minister. Of course, that is easy going. And there are others who come in and hear about competition law, competition policy, literally in a way for the first time. And of course, that is more difficult. But I think in which we always succeeded was to make clear how important competition is and how important it is to have an independent competition authority that takes care of that competition. That is kind of the fundament of the economy here in Germany and Europe. So a quick answer is it depends. Sometimes it's much fun, but not always.
Yeah, look, I think sometimes it can be difficult, I think, to be honest, depending on decisions you're making. We've had in the past, particularly in merger review, where there are criticism coming from political parties in relation to some of the decisions we make. And so that is always going to be a concern. And I think, Matthew, you're right, remaining independent, but ensuring that we do good quality work of the work that we do is what helps us as competition authorities to say to those who we serve that we're doing a good work. But it doesn't move away from the concern you're raising, and that is the reality. We are still established by politicians. And so to the point you started with, Matthew, of concern of how the independence of competition authorities is reducing in some areas. It's a reality, and we need to have a voice in which we encourage the independence of competition authorities, I think. Thank you.
And just to add one comment that I kept meaning to say the whole panel, something that's become very obvious to enforcers around the world in the last few years, and a real point of emphasis, is communicating in their jurisdictions using plain language and explaining to the citizens of their respective countries why competition is so good for them, explaining to businesses why competition is so good, explaining to politicians why it boosts productivity, it boosts innovation. And the more we do that in terms of plain language, the more, in my view, the more long-standing, sustained support we're going to have by citizens and by politicians when we get away from the technocratic language of antitrust that was very easily used 20 years ago to really communicating directly with people. I think it goes a long way to have politicians support competition because the citizenry supports it and understands it and understands why it's good for their lives.
So we should not start with the SNP test. That's
Exactly. Or the cellophane fallacy, whatever that is.
Well, please join me in thanking our excellent panelists. Thank you so much. We will now have a short coffee break and we'll reconvene at 12 p.m. Thank you.